Hello and welcome to episode 81 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director.
I'm Joanna Baron, the CCF's executive director, and in today's episode, I'll tell you about what's going down at my alma mater, McGill University.
And I'll walk you through an Ontario Court of Appeal decision that found Doug Ford's COVID-era protest ban actually did violate constitutional rights.
Plus, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about the CCF's new lawsuit. Assisting professors and a former PhD student at UBC, University of British Columbia, who feel they're being silenced by the politicization of the university. So for those who haven't heard this news yet, we're asking the court to order UBC to comply with its requirement to remain non-political. And if you don't think the university has been getting political, you probably haven't been paying attention. It's important to know here that UBC is actually a public university. It's one of the first truly public universities. I just read an entire book about the history of UBC and its founder, Frank Westbrook, who wanted this to be a university that wasn't, an elite institution tied to a church, like a lot of other universities were at the time. McGill, for example, was very religious. And this idea was that there would be a university for all, and that's reflected in the university's motto, which is Tuum Est. And that means it's yours and it belongs to you, it belongs to the people of British Columbia as a whole. And those people still fund it as taxpayers today. This is also reflected, though, in the law. So Section 66(1) of the University Act in British Columbia says that UBC must be non-sectarian and non-political in principle. So yes, there's actually a law in BC that says the university, its administration, needs to be non-political. And the applicants in this case all argue that the university administration has violated this statutory requirement, and there are three big examples that we give in our petition filed earlier this week. So the first is that the university frequently declares in its official communications, it's posted all over the website, that UBC is on unceded Indigenous land. And whether you agree with that or not, it's pretty clear that that's a political statement. And while many professors, many students agree with that, many don't. And they want to be able to debate that and study that. But that official position is now being pushed by this university that's supposed to stay non-political. The second big example in our petition is that UBC not only adheres to DEI in its hiring, so not only do they have sort of affirmative action programs, but they now require in many of their job ads that applicants strongly commit to or agree with DEI. And many classical liberals or conservatives don't actually agree with that ideology. So they can't even apply for jobs in good faith at UBC since it now has this political litmus test. And third, what we've seen in the last couple of years is that many different parts of UBC's administration have been making declarations related to the Israel and Gaza conflict. And these range from, merely condemning the October 7th attack to calling Israel's response genocide. And obviously, individual professors have academic freedom and they ought to be able to take various positions on that, but there shouldn't be any official position taken by the university, and yet that's what we keep seeing. So the problem here is when the university administration takes official positions, it limits the academic freedom of students and professors. And that's because the administration has control over things like your tenure, whether you're hired in the first place, your teaching assignments, all that stuff. And so we've got 5 petitioners here. 4 of them are professors, and the 5th is that the former PhD student. And he, for example, the student was a classical liberal, so he doesn't believe in DEI. He believes in equality of opportunity, and he's one of these people who now can't even apply for a job there. And he was also, pressured in all kinds of other political ways by administrative officials. For example, he didn't think feminist theory was relevant to his dissertation, but he was pushed to include that. And then at his defense, there was a land acknowledgement, and people are welcome to do land acknowledgements. A lot of people think they're like a polite or important thing to do, but there's no question that's a political statement, and people should be able to, do their dissertation without having to endure a land acknowledgement with which they don't agree. It would be like somebody coming in and doing a prayer at your dissertation that you don't agree with. Next up, we have a tenured professor. He's been there for more than 35 years, philosophy professor who's been at the UBC Vancouver campus and is now in UBC Okanagan. He's held all kinds of administrative positions, so he really knows how this is supposed to work. And he's been pushing for years internally to get the university to stop being political, but it hasn't worked, and that's why we're now at this place where we're doing this legal challenge. You've got another professor. He works in English and cultural studies, and his faculty, they actually made a statement on Israel and Palestine, a very political statement. He didn't think that this was right, that it should be made on behalf of everyone in the faculty. There's nothing wrong with an individual doing this, but now you have these official statements happening as well. So, like I said, this violates academic freedom, and it matters because, when the university officials are taking positions on political issues, those start to become off limit for students and professors to research and to teach. And it basically becomes impossible for them to do their jobs. And that's how a lot of these professors and former students feel about this. Academic freedom is a bit hard for a lot of people to understand, but it's a lot like freedom of expression. So they basically serve the same purpose. The idea is that you want to prevent censorship so that individuals can find the truth. They can put forward new ideas, test out those ideas. And with free expression, it's, the individual vis-a-vis the government. With academic freedom, it's the individual professor or student vis-a-vis the university administration. So I'm really excited about this lawsuit. I've noticed UBC in the 15 years, God, I'm old, since I went there, has become very political. And it was a little bit political back then, but it was the type of place where I still felt comfortable as someone with, more classical liberal views expressing my opinion or doing research. But I don't think I'd be very welcome there today. And so that's why I'm really glad that, the CCF is getting involved in this. And I hope we get the order that we're looking for. Joanna, you mentioned your alma mater, McGill. You always mention that you went to McGill for some reason. I know you're going to talk about that
Because
more
I
today.
loved it. It was the best time of my life. No,
Funny,
that's not true, but I did really like it.
funny that Christine and I don't mention Osgood all that much. But anyway, so you were there more recently than I was at UBC. What was it like then? Was it so political that you couldn't do the teaching and research that you might want to do, or have things just gotten worse and worse since then?
I think things have gotten worse and worse, particularly at the university governance level. And we'll talk about, McGill is trying to get out of that game because they see that it can lead to basically mob takeover, as we've seen at other schools. Like that's what happened at Evergreen College, right? People forget about Evergreen College, but go back and read what happened to, what was it, Brett Weinstein? And his wife, who basically like a mob decided to surround their offices, physically menace them. And then the most shocking part was the university leadership was like, yeah, we can't do anything about this. Like the mob's gonna mob. That's terrifying. But UBC is basically, they've taken on they are the mob now. They've taken on the role of the mob. And I think it's hugely problematic, and it's hugely harmful to academic independence and academic freedom. I saw, by the way, is his name Jeffrey Sachs, that guy on Twitter?
Yeah.
Yeah, so Jeffrey Sachs responded to one of your tweets about this, and he was like, this seems bad. for many reasons. But one reason is that if you guys win, will that mean that professors won't be able to make political statements? And you had a very obvious answer, which was no, because professors enjoy academic freedom, which the university governance and the university as an institution doesn't. And he was like, but if the statute is interpreted the way you say, wouldn't that take precedence over academic freedom? And this is a mini bad legal take.
Yeah.
The whole idea is protecting the freedom,
Yeah.
academic freedom of the professors
Yeah.
from the administration, not to attack the academic freedom itself.
Yeah. I generally like that guy's tweets, but I was like, wow, that's such a bad take.
Yeah, he's right to be concerned about, using statutes, for example, to enforce particular viewpoints, but that's the opposite of what this statute
Right.
does, right? So any other statute where the government's going to come in and, tell the university how to act, normally be concerned about that, but this one actually does the opposite. It preserves institutional neutrality. It's like should be the gold standard for every province that wants to solve this problem with the universities that they fund. So, yeah, I think that is a bad legal take. Christine, what do you think?
Well, what's been really cool to me is to see the reaction to this lawsuit, which we're in like a group chat with a bunch of different lawyers, and one of them wrote to you, Josh, saying, "Josh, I could kiss you for this lawsuit."
Yeah,
He's
I'm
so
accounted for.
excited.
Sorry, Jen.
But I've sent it to another group of professors that I met with when I was in Vancouver a month or so ago, and they are just ecstatic, and they're sharing it through their network. You are getting nonstop media attention. We were supposed to film this earlier today, and we had to push it back because you keep getting back-to-back media interviews about this lawsuit. It is such a big deal, and I'm happy that you explained it so clearly. But I think what people need to know is how huge this is. This is going to be a really, really big deal, and I'm so thrilled that we're taking this on. It's really exciting. It's been really distressing to see the environment that a lot of professors who have maybe unpopular viewpoints or conservative viewpoints, what they experience on campus, and how ostracized they can be for expressing a viewpoint that might be different from some of their peers or from the administration. And the fact that ostracization is led from the top, it shuts down inquiry, which is the exact purpose that universities exist for. But I'll turn now to my news headline, which is more exciting news, which is that there's this case from Ontario dealing with COVID restrictions, pandemic era restrictions. Yes, those are still making their way through courts. And this is a big victory. And we haven't seen a lot of resounding victories in COVID era litigation, but this I think counts as one. So the case is called Hillier and Ontario. It involves former member of provincial parliament, Randy Hillier. A lot of our listeners might be familiar with him. And he challenged gathering limit restrictions during the pandemic, and he won. And this is a fascinating case because it considers an underdeveloped right, freedom of peaceful assembly. That's Section 2C of the Charter, which is often treated by courts as a derivative right of freedom of expression. It's not treated as a standalone right in a lot of cases. It's treated as, sometimes it's just not even considered at all when there's a protest restriction. It's just the courts go straight to 2B, freedom of expression. They don't even consider 2C. There's just not a lot of case law on 2C. And now this case makes it very clear that this is a standalone right. And the court also held that the gathering limits did violate this right to freedom of peaceful assembly, and that the limits were not justified under Section 1 of the Charter. So let's get into it. There were two regulations at issue here, a shutdown order and a stay-at-home order. Remember those terms? They all meant different things. Like we had a lockdown, a shutdown, a stay home, and they all did different things, and they all worked together. And these two orders, the shutdown and the stay home, prohibited people from attending certain gatherings. And then they had a few exceptions. You could have a gathering for a wedding, a funeral, or for a religious service of 10 people or fewer. but you could not have a peaceful political protest. There was a total prohibition on that. And that's the type of activity that Mr. Hillier wanted to engage in. And he did. He went to these and organized these peaceful protests. These protests were not disruptive. They were not violent. They did not attract counter protests. There were no criminal activities. There were no criminal charges. The court described them as vanilla outdoor political protests. And because Hillier did them, he organized these protests in Kemptville and Cornwall in May and April of 2021. And he also attended some other protests in other parts of Ontario throughout May and April of 2021. And he was charged with violating these regulations. And the purpose of those protests was to amplify collective opposition, expressing discontent with the lockdowns, stay-at-homes, whatever, shutdowns, all of these COVID measures. So he was charged with these provincial offenses related to these gatherings, and these charges could result in fines between $10,000 and $100,000 and could result in up to 1 year imprisonment. And after he was charged, he challenged the constitutionality of the regulations imposing these restrictions on the basis of the right to freedom of a peaceful assembly. And he said it couldn't be justified. He lost at the lower court, but this was now at the Court of Appeal for Ontario. And what the Court of Appeal did that was interesting is they actually considered 2C. The government had conceded that 2C was violated, that there was the gathering limit was a violation of the right to freedom of assembly. They just wanted the fight to happen on Section 1, whether or not this was a justified limit. But the court said, no, even if you've conceded it, we're still going to look at what constitutes a 2C violation because we need a principled basis for understanding the violation in order to determine if it can be limited. It's a precondition, they said, to an informed Section 1 analysis. It's not enough to just concede that there was a violation. We need to understand the violation. So in this case, in considering 2C, the court acknowledged that this is a jurisprudentially underdeveloped right that has received little to no attention for the first 40 years of the Charter. It then considered a number of academic papers because there's just not a lot of case law. It considered papers written by Professor Jamie Cameron. She's a retired professor now from Osgoode Hall, and Professor Richard Moon from Windsor Law. Both of these papers were considered. Josh and I think Joanna, I think we've all read Jamie Cameron's paper. I don't agree with all of her paper, but the part that the court quotes here, I think is pretty unobjectionable. The part that is quoted is what the court calls an explanatory thesis for 2C. And that thesis is that thought, freedom of assembly are not the same, that assembly is its own constitutional event, and assembly is not a derivative right of expression, and that expression and assembly, although they tend to converge because assemblies are necessarily expressive, that doesn't mean that the analysis on assembly is just identical to the analysis on expression. Assemblies are a separate, independent freedom, and treating the right as derivative would unduly limit protection for people living in a constitutional democracy. So these protests are given by the court constitutional protection as peaceful assembly because of 2C's role in democracy. And that role, the role of an assembly, is to validate the legitimacy and value of experimental, collective, and public democracy and political participation. And in this case, the ban on assemblies for political protest was absolute. Peaceful assemblies were not permitted, even if the numbers were small and consistent with the limits for other permitted gatherings. So the 2C protection is of something fundamental. The court acknowledges this key role in democracy. The protection exists so that dissenters can attract attention in a visible act of solidarity to their opposition to a law by disrupting ordinary life in the hope that the protest will lead to a change in public policy. This freedom is, according to the court, elemental in democracy, and alternatives to it, which the government has suggested, in public discourse, they said alternatives existed, like having an online protest, like a virtual Zoom protest. Remember this? Remember this? Oh my God, I hate thinking about it. A Zoom protest or just posting on social media. The court says all of that is not sufficient to achieve the purpose of protest in democracy. So the right is separate and protected. Then the court turns to the Section 1 analysis and concluded that these gathering limits were not justified because they were not minimally impairing. This was an outright and absolute ban on political protests. It was a total ban on the exercise of a fundamental freedom. And the court said that that cannot readily meet the second step of the proportionality analysis either under Section 1 of the Charter, and which makes it disproportionate. So the negatives outweigh the benefits. And the harm here is that the fundamental freedom to assemble was deleted entirely for 2 months of our lives. Some gatherings were permitted in certain circumstances, like the weddings and funerals, but individuals or groups who wanted to protest the COVID measures in particular, they were prevented by law from doing so, either indoors or outdoors. And, an outdoor protest is an effective way of amplifying minority voices and expressing political dissent. So people who wanted to participate in those were denied the opportunity to influence public policy in this, what the court calls a time-honored method. And what was really fascinating was kind of at the end where the court said that it cannot countenance the elimination of the free exercise of a fundamental freedom without the state giving the elimination of that right any actual thought. So the court said that the government had not actually even considered exemptions for political protests, and this cannot be accepted in a democracy. So what happens now? We actually kind of need to wait because obviously this whole thing is moot. In terms of the validity of the law, it doesn't really matter. The law is no longer in force. I suppose the convictions will no longer stand for these provincial offenses, but the Hillier needs to make submissions separately on what remedy he's actually seeking. So that's going to be dealt with at a separate hearing, is my understanding. But what's great about this case is this provides a lot of guidance on the scope of the right to freedom of assembly, guidance we didn't previously have, where there was conflicting case law on if this even exists as a separate right or if it's the same thing as freedom of expression. It could be the new leading case on freedom of assembly. It could be relevant in our work on the Emergencies Act, where there is an active question about the 2C protections and how they were impacted by the use of the Emergencies Act. And this case might even, who knows, the government might appeal it. It might go to the next level of court. If it does, that's obviously something worth watching. Josh, I know that you have some thoughts on the decision and on the inclusion of these papers, the academic papers in particular. Is there anything you want to tell us about any of that?
Oh, I have so much to say, but I'll keep some of it to myself. So I think this is obviously the right outcome. I was basically enraged for the entire period when this was happening, thinking, how can you possibly ban political protests when you're allowing other gatherings to happen, like the NHL games or funerals or I think church services to some degree. Maybe it was weddings. There were anyways certain gatherings were allowed, but the gathering where you might go and actually criticize the lockdown policy itself, that was completely illegal. So I think it's the right decision in the end. We didn't get as much guidance as maybe we would have liked on what freedom of peaceful assembly actually covers. And I've been working on a paper on this with a UBC professor. And, there's two things that you have to, there's three things you have to define. You have to define freedom and peaceful and assembly. And The courts have told us freedom means the absence of coercion or constraint. That's sort of the Coles Notes version of freedom. Peaceful, some people argue peaceful just means nonviolent, but I think it actually has more to do with not coercing and constraining people, although, we're still at the early stages of this paper. And then when we're talking about what assemblies are protected, the Cameron paper, it seems to suggest it's mostly just protests that we're talking about that are covered by freedom of assembly. And, she talks about the purpose being this sort of performative act of expression, and also, there's solidarity you feel with other people at the protests, and certainly those are aspects of that type of assembly that I think are really important and distinguish it from expression. But we're leaning towards in our paper saying no, every assembly is protected, whether it's sitting inside an NHL game or whether it's meeting someone for dinner and having a political debate in your house, and not just protests. So
Yeah, I'm inclined to your interpretation. We wrote about this in Pandemic Panic as well, actually.
yeah, and so that's sort of where we're at. So we didn't get a lot of guidance on that. I think Cameron is right about a lot of things. I don't think she's right about everything, but the Coles Notes version of this is, this is a big win for constitutional rights and freedoms, and it's about time because judges were decision after decision doing what this judge did, which is saying, just to quote, he said at paragraph 105, this is the lower court decision where he upheld the government's ban. In the extraordinary circumstances existing in 2021, the gathering restrictions were necessary and proportionate response to the most significant health crisis of our time. That's just not good enough. You can't just say there was a really bad pandemic, therefore it's fair game to limit all of your constitutional rights. The government actually has to prove that those limits are demonstrably justified in a free and democratic society, and saying no one can gather with any other person outdoors for a protest is just not acceptable, especially when all these other gatherings were allowed. So right decision, and yeah, I'll shut up now. So Joanna, I'm sure you have thoughts too.
I actually think we should move on to my news headline because I think you guys said everything that I wanted to say, and I'm mindful of the time. We're trying to be a little less long-winded. Let's take a break and we'll come
Ouch.
back. You can cut that out. Let's take a break, and when we'll come back, I'll tell you about the roiling at McGill University. Okay, so this week, a bit of a bombshell, McGill University leadership announced that they are initiating the process to end their contractual relationship with the Student Society of McGill University, otherwise known as SSMU, aka SMU. And this is following pro-Palestinian protests that led to classroom blockades and vandalism. And the university also announced that they have begun a 2-week mediation process, which will be decided in June. So in an email to students, interim deputy provost Angela Campbell emphasized that while protest is protected, there are limits. She wrote, "Protest is indeed part of university life. Our policies and the law protect peaceful assembly and freedom of expression, but vandalism, obstruction, threats, and violence do not fall within these protections." And Campbell directly addressed the recent incidents. She said, "Last week, SMU allowed and at least tacitly supported a 3-day strike that further divided a campus community already deeply cleaved and hurting." And she described what happened. So dozens of classes were blocked or interrupted. There was a specific incident where individuals smashed through a glass office door using a fire hydrant filled with red paint that was sprayed throughout the office while staff were inside. And Campbell declared, "Let me be clear, no one at McGill, no student, staff member, instructor, or faculty member should ever have to experience this at their place of work or study. This behavior is unacceptable." And it should be mentioned that Angela Campbell, who is a family law prof, or was a family law prof, now I guess she's in Central University leadership. She was a family law prof at McGill Law. She's like a very well-loved professor. I had the privilege of being her RA. She's awesome. She's just one of those professors that's like your friend immediately, but super, super smart. But Campbell, I found out, had her own home protested last summer, targeted last summer during the ongoing McGill encampments that dragged on like far, far longer than any other encampment. She has young children, and those protests were known to resort to violence and smashing windows. So I certainly understand how she wouldn't be well disposed to any of this. Not that I think her decision discloses personal bias, but just some context. A bit more context, though, about SMU. So before McGill's announcement, SMU had issued a statement on April 4th addressing the incidents. The union clarified that while 72% of voting students had approved the strike in a referendum with 17% participation, the approved mandate specified that the actions would remain, quote unquote, peaceful and voluntary. And SMU condemned the disruptive behavior. They wrote, recent reports and evidence have emerged of antagonistic activities occurring on campus by those claiming to be affiliated with the strike, including but not limited to classroom disruptions and violent altercations. And they said these actions are neither in the spirit of the strike motion nor SMU's internal policies and regulations. So they do seem to be distancing themselves from these incidents. SMU president said that there are enforcement limitations, that basically there was nothing that they could do once the strike had started to stop it from getting out of hand. And obviously, they're not happy about this. This will affect their funding, although it should be noted that as a ratified student organization, SMU is entitled to some provincial funding, so not clear what the bottom line is. There's been a lot of criticism about this from within the McGill community. Another law professor, Victor Muniz-Fraticelli, has a tweet thread where he said, Angela Campbell just canceled an agreement with the student union that provides one of a few campus daycare facilities. He questioned her motives. He wrote, I'm trying to figure out if Campbell did this out of obstinacy, stupidity, or malice. And he suggested that SMU did the absolute minimum to promote the strike and sent out a communique condemning all confrontation. And of course, the Student for Palestine's Honor and Resistance group has expressed their support for SMU. Which I think is a first time. Because SMU, by the way, as I'll mention, is actually not one of the fringe groups on campus. It's one of the more centrist groups on campus. But anyways, I have some priors with SMU to come clean about before I share my thoughts. I was a McGill undergraduate in the early aughts, fresh on the heels of the Second Intifada, and it was praised pretty across the board by all of the McGill student groups and also SMU, but especially the independent student newspaper, the McGill Daily, which, to be clear, is not affiliated with SMU. And I just checked today, and the Daily is unambiguously wide-eyed and pro-violence, pro-demonstration. But SMU has never been exactly morally clear-eyed, let's put it that way, about this stuff. And of course, McGill's decision is operating within a context of tension between campus safety, the ability for academics to go on, student autonomy, because SMU is their democratic response body, and what is a proportionate response. And they've seen from the ongoing encampments on the campus that the Montreal police are fairly useless in remedying the problem. There was all kinds of incidents of anti-Semitic conduct, harassment, vandalism, and the Montreal police did nothing. It seems like in this incident, the Montreal police, there was riot police that did come into campus when some of these strikes were going on. So at least the police have started to do their job. But it does make it more complicated that SMU explicitly condemned the violence. They said it was not in the spirit of the strike motion. They said that it was intended to be peaceful and voluntary. Now, that could be that was reckless or naive, particularly because this is, to say the least, not the first time that this has happened. We've seen this happen episodically on this campus since October 7th. But I still think The deputy provost Campbell's decision raises questions about whether the response is appropriately distinguishing between SMU's official position and the actions of individuals or groups which really operated beyond SMU's control or mandate. Of course, the university has valid concerns about safety and the environment, but I'm not sure if severing ties with the entire student union is a proportionate response. And the decision, of course, will affect services like daycare and club funding that benefit many students who had nothing to do with it. So these are real governance challenges. Some people have suggested that McGill is doing this as a way of getting a leg up and leverage in the mediation proceedings. And McGill has just been a tempest in a teacup. And my 2 cents is that rather than sever ties with SMU, which is overbroad and, to be honest, in some ways cowardly, the university should put their money where their mouth is and identify students involved in the acts of violence or vandalism, refer them to the police so that they're arrested and charged, and expel students that were involved in this. That would be more morally courageous and it would be more targeted. But what a mess. So, Josh, I know that you get an allergic reaction whenever the word SMU or the acronym SMU comes up. But what do you think? Is McGill in the right here?
Well, I mean, this is bringing back memories of the Maple Spring and all of the student unions having, 20% of people vote that they're going to go on strike, by which they mean, shut down all the classes. And I just don't think that's ever appropriate. If it was up to me, honestly, I would cut ties with every student union in Canada. I don't think universities should be collecting large amounts of student tuition every year and handing it over to these like hostile advocacy groups. Like, I realize some of them do some good and that they advocate, and they're not all super crazy, but like, I actually don't have any problem with just cutting ties, whether it's right to do it for this particular reason. I don't know all the details, but like, I say screw SMU, get rid of all of the student unions. I hate them all.
Oh, and here's a hot tip for any McGill student, or could be other university student, but McGill, at least when I'm back in the day, you could opt out of your SMU dues and you would get a refund back. So,
That should always be the way. I mean, Doug
yeah,
Ford tried to do that here and the courts overturned it. They
yeah.
said, no, it's up to the universities. And it's like, okay, well then the universities should be cutting ties with some of these crazy
Get those
students.
dollars back.
Yeah, well, I mean, if people want to give money to a student union, they should be able to do it, but the university shouldn't be able to, collect everyone's money and hand it over to these groups, in my opinion. Anyway, Christine, what do you think?
I don't really, I just don't care about this SMU group. I don't care that they have been kicked out or whatever it is, that they've had their arrangement ended. I don't really understand what the purpose of these student unions is. I don't see why the services that they're provided couldn't be provided by another contractor that's less, you say they're not radical, Joanna, but I mean, just a normal company to
Yeah.
provide businesses. So I just have trouble really getting worked up about this because I just don't really like most of the people involved. And that's not a principled way of thinking about it. But I'm also in favor of your alternative, which is basically I like both Joanna and Josh's suggestions, which is to expel the violent students and get rid of the student union.
Yeah.
That's like winning all around. That would be the best scenario, I think. I mean, I honestly, like, that's kind of a hot take because I just don't really know. I'm so removed from this at this point that I don't really know the role that this organization plays. So it's hard for me to get really worked up about. But you know what I do get worked up about is Rachel Gilmore. So I'll turn now to my bad legal take, which is a comment on one of my recent recent YouTube videos. So I did a video where I went through, what different political parties, the grassroots, have said as their resolutions about free speech. I did a little analysis of it and talked about why free speech is such an important issue in Canada, why it should be an election issue. And someone replied to me saying, Anyone who thinks we have free speech in Canada has not heard the phone call from CTV to Rachel Gilmore. CTV had hired Rachel to do a fact-checking piece, nonpartisan, on Fridays on CTV. In spite of her appearance on CTV getting very positive feedback in comments, Gilmore received absolutely horrible personal feedback, including a death threat. Okay, death threat, not okay. And then CTV let Rachel Gilmore go. Support her. You should listen to what CTV said when they fired her. Is that constitutional? Yes, it is constitutional to fire a journalist. The Constitution does not apply to CTV and its employment, and this isn't even an employment relationship. They had offered to, I did listen to the phone call, in fact, and CTV was going to have her on, I think, 4 segments on Friday to do a fact check on election claims by different party leaders. A lot of people on Twitter and on social media objected to this because Rachel Gilmore is perceived by many as a bad faith operator and a political activist who is not nonpartisan. She is a very activist with a person with a clear perspective that's hostile to the Conservatives. So a lot of people were not happy that she had been selected. What CTV said was that they were not going to continue the segments. They would still pay her, but that they were getting too much backlash and it was creating a distraction. And they are allowed to do that. There is no constitutional obligation to continue this relationship with Rachel Gilmore. In fact, I think it was a good decision to get rid of her because, in fact, there was some negative feedback of her fact check because her fact check, the one that she did do, had an error in it. I think it related to Prime Minister Turner or something like that. There's a bunch of people pointed out a mistake that she had made in that. So if your fact checker is making factual errors, it's not a very good fact check. The Constitution doesn't apply. This is an activist and people were mad. Totally fine to get rid of her. Josh, what's your bad legal take this week?
So I want to talk this week a little bit about double standards in policing because I'm getting really sick of it. So a man named Daniel Tate was in court today here in Toronto facing mischief charges because he spray painted the words "Free John" on the plywood box that's been surrounding the Sir John A. Macdonald statue outside of Queen's Park here since the whole, moral panic about Sir John A. and his connection to residential schools. Never mind all of the amazing things John A. did, like, create Canada and build a railway in a decade that connected all of these fledgling provinces together. So Tate was charged and, he could face up to 2 years in prison. But meanwhile, the people that actually tore down John A. Macdonald statues in Montreal or tore down a statue of Queen Victoria in Winnipeg, they were not pursued by police, and Crown prosecutors specifically said, no, we don't care, it's fine. I guess because they have the right politics or maybe the right skin color. So, also here in Toronto, we've seen a year and a half now of anti-Israel, pro-Hamas people terrorizing people in the streets of Toronto using loudspeakers, which are, chanting things like "kick the Zios out," burning the Israeli flag on top of some wooden scaffolding the other day, and blockading intersections week after week with no consequences, no arrests. And, police know exactly who these people are, but they just let them go, I guess, because they have the right politics. Meanwhile, if you're this, white conservative male and you commit this minor act of mischief, you're in court with a huge lawyer bill and, a potential jail time and a record. And, even if his record is, even if he's not convicted, he's still going to have a Toronto police record, right? So getting sick of the double standards. Another one is look at Tamara Litch and Chris Barber last week. They're convicted of mischief for counseling other people to blockade in Ottawa during the Freedom Convoy. And we don't condone any blockades here, but why is one type of person getting arrested and having the book thrown at them while the other crowd, the sort of left-leaning or pro-Hamas crowd, just gets to do whatever they like? So That's my bad legal take. Either start arresting everyone who commits mischief or don't arrest anyone, but the double standards need to stop.
Okay,
Joanna.
my bad legal take goes to the town of Saint-Amable, Quebec, which has implemented a $200 annual tax on residents who don't have a tree in their front yard. And they're using mobile scanning technology to identify yards without trees. Approximately 400 homes received the charge, and town officials are calling this an eco-fiscalité measure. Okay, so first of all, this is a terrible idea and an interference with basic property rights. Second, this is already being enforced arbitrarily. There was a resident named Sarah Kim Orobello, was penalized despite compliance just due to
She had a tree.
yes, paperwork issues. And when government action depends on form submission than compliance, which, shocker, they're going to make some mistake. We're in bad territory. Third, the classifications are a mess, and former mayor Simon Lacoste has noted residents with shrubs, I'm not making this up, instead of trees are being taxed. So it's a gray area. Fourth, the burden of proof is being reversed. So if you're a resident, you have to prove that you're compliant. So there's effectively a presumption of guilt here. So anyways, this is a mess, and you can take your eco-fiscalité and put it where, Saint-Amable. This is a bad idea and a very bad legal take.
Wow, I think we found a new case, Joanna.
Yeah.
I love that.
Finally found the property rights case we've been looking for all these years.
Yeah.
All right, so that's it. That's the end of the show. We hope you'll rate us, review us, and subscribe if you haven't already. And you can support our work by subscribing to the CCF's YouTube channel, which now has 100,000 subscribers.
Yeah.
Congratulations, Christine.
Congratulations.
Thanks.
And also, if you haven't already, go and sign up on our website for the Freedom Update newsletter, which is now from our new colleague Jess, instead of our colleague Russ, who's moved to a different position within the organization. The CCF is a nonpartisan legal charity funded by your donation, so please click that donate button on our website if you can. Thanks for listening.